So you have a license?
For what?
So I got
The stop is right here, Bubba.
What's that?
The stop is right here with him. I'm the passenger.
Yeah, you have to give me your ID if you're a passenger.
For what? What law?
You have to give me your ID.
What law is that?
You have to give me your ID if you're a passenger.
What law is it?
There's case law on that.
Okay. You want to take me to jail for it?
I'm telling you, just give me your ID.
I'm not going to give it to you.
Okay, get it, Bubba.
You're going to arrest me for not IDing as a passenger?
Are you refusing to identify yourself?
Yes.
You're refusing to identify
Yes.
yourself. Okay, fair enough.
What was your name?
I tell you to identify yourself. You refuse. So I step out. Listen. I was conducting investigation, so I can meet
So
with my
I have
partner.
to-
Listen. I talked to my partners to see if this is the vehicle that we're looking for.
And it's not.
It's slightly different. So I didn't. That's what
Like a man, give me your hand.
Okay, it's not about me
I'm
trying to.
I'm not going to give you my
I don't want your name anymore. Now I know.
What you asking for?
Right, but now I know.
And you handcuffed me for it.
That's right.
But you know you're going to get sued. I appreciate
You
it.
dispelled my suspicion.
I'm a police instructor and trainer. I train and instruct law enforcement all over the country on various law enforcement disciplines to include case law, constitutional law, patrol tactics, etc. And in this case, we can clearly see that we have a passenger who is not going to give his identification unless he's compelled to by law. And as we know, that Supreme Court case precedence for that, it's going to be Brown versus Texas, 1979. I do like the fact that he did comply with the officer's instructions and orders to exit the vehicle as what he would be required to pursuant to in accordance with Maryland v. Wilson, 1997. And so what I like about this video, okay, and I make no qualms about this, I like the fact that you have somebody that is asserting their rights. I mean, we have to be very clear. And I know law enforcement doesn't like to hear this, and that's fine. My job is not to placate towards law enforcement. My job is to be honest and be truthful and to do everything I can to train law enforcement so that they're not in a 42 USC 1983 qualified immunity debacle, right? That is my job. My job is to train and instruct law enforcement and give them the most tools and the tools needed to do the job. That's very difficult and very hard. I make no argument about that, and my biases are very clear, and I'm telling you what they are. And so, I love the fact that you have a citizen that's asserting his rights. I think that's needed. I think that's important. And equally important, we need an officer that knows what his scope is and what he can and can't do. And it seems like this officer seems to think that just because he's conducting some kind of investigation that everybody's required to somehow submit to that authority of his investigation, right? This magical investigation story that we hear about. The fact that I'm conducting an investigation means you have to follow all my orders. And we know that's not the case. We know there's applicable case law, again, that we have to be cognizant of. And so what's really, for me, the frustrating part about this whole video is the fact that he very well may have all the elements for, reasonable suspicion. He just doesn't know how to articulate it. He just doesn't know what they are. It seems like they're looking for a vehicle that's committed some crime. And that's great. But the problem is, right, and this is something that I see all the time, reasonable or articulable suspicion, RAS, that should be an elementary level thing that law enforcement officers are taught. That should be something that they know before they come out of the academy. They should have a strong base and knowledge of what reasonable or articulable suspicion is. And the more classes I teach, the more videos I watch, the more officers I encounter, it's very clear to me that this is not something that's mainstream talked about in academies. It's something that may be touched up upon, but the case law on it certainly isn't being talked about. And this goes with not just rookie cops, but well-seasoned FTO officers that I've met. What's reasonable articulable suspicion? Explain it to me. What is the case law that guides this? What are elements that the Supreme Court has already affirmed are elements of reasonable articulable suspicion? And a lot of them, most of them that I come in contact with, unfortunately, don't know. And so that's a big problem here because this passenger is doing everything right. The officer is trying to use these words. Are you saying you're failing to identify? Well, yeah. If you don't have reasonable articulable suspicion of a crime, I'm absolutely refusing to identify. And depending on the kind of person he is, if this is one of those true to the cause type of activists, he wants you to arrest him because he wants to sue you. Then he has you in that 42 USC 1983 predicament that we talk about. And guess what? It's over. It's over. And I hope more officers realize that. And I hope more officers put forth training and understanding the baseline elements of policing. In my opinion, I believe reasonable articulable suspicion is probably as baseline as it gets. And I think more departments across the nation and more academies need to do a better job of teaching this and instructing this. But overall, I really liked the passenger. He was respectful. He stood to his rights, and you could tell it was very clear. He wasn't afraid of arrest. And if more citizens weren't afraid of unlawful arrests, or illegal arrests, I should say, if more people in this country weren't afraid of of illegal arrests, I think things would change a lot quicker. But we shouldn't be at that point. We shouldn't be at the point where citizens have to subject themselves to unlawful arrest for law enforcement to get the training and help that they need.